Ranking Member Tillis and his staff for working so closely together with me and mine on a consensus basis. You and your team, Senator, have been a great partner on these issues, and I thank you for your partnership and leadership. Today, we're going to explore foreign threats to American innovation and economic leadership. This is a timely and critical topic, and I'm looking forward to a productive conversation. America's leadership on the global stage depends on our ability to foster and protect innovation and creativity, both at home and abroad. Our competitors and adversaries recognize this fact. China, for example, has been trying now for decades to unseat America as the world's innovation superpower. To do so, Chinese government and companies collaborate to acquire foreign technology and create domestic innovation industries. This isn't a surprise, as IP drives economic growth. The USPTO reported that in 2019, IP-intensive industries, things like computer technology, pharmaceuticals, entertainment, accounted for nearly 50 million American jobs and 7.8 trillion in economic value, representing 40% of our GDP. Innovation is a key driver for our competitiveness and our national security. China's focus on IP raises national security concerns and questions about how China is manipulating rules-based international systems to its own advantage. We'll explore those concerns and questions today with our panel of witnesses. China has pursued innovation and economic supremacy in part by using illegal means. Brazen trade secret theft and economic espionage by China is well documented. According to the Department of Justice, approximately 80% of the economic espionage cases it prosecutes involve trade secret theft by the Chinese government or its agents. Trade secret theft has touched my own state of Delaware. Our oldest or perhaps best known company, DuPont, Chinese nationals stole trade secrets protecting their innovative titanium dioxide production technology and sold these secrets to a Chinese state-owned company for $30 million. We also need to be concerned about the threats posed by counterfeit goods, often sourced from abroad. In 2021, 4/5 of all counterfeit goods entering the United States originated in China. Although we seized $3 billion of counterfeit goods at the border last year, this amounts to a small fraction of the total. These counterfeit products can be unsafe and harm consumers. As co-chair of the Congressional Trademark Caucus, alongside Senator Grassley, I know just how challenging and dangerous counterfeits can be. For example, prescription drugs that are counterfeit may not contain the active ingredient or can contain even worse deadly elements like fentanyl. Fake airplane parts, widely found in service centers around the world, can increase the chances that a plane malfunctions or crashes. Beyond illegal means, China has increasingly used legal processes to unseat America as the world's economic and innovation leader. Although these means haven't received as much media attention as illegal activities, they're equally as harmful and more difficult to combat. China has manipulated standard-setting boards and flooded the USPTO with trademark and patent applications to slow down all of its work. The threats to our economic leadership and our innovation ecosystem aren't just from China. Other countries like India have also been inconsistent in their IP protection and enforcement, for example. At the same time, emerging weaknesses in our own IP system have made it more difficult for rights holders to assert their rights, protect themselves, and safeguard their IP from either domestic or foreign threats. Patents are today easier to challenge in the PTAB in trials than in district courts. Patent owners who prevail in litigation can no longer rely on securing permanent injunctions to prevent ongoing infringement. I also remain concerned about unresolved issues around the scope of eligible subject matter or patentability. More than a decade after the Supreme Court waded into patent eligibility law, confusion reigns about what areas of innovation are still eligible for patent protection. Critical technologies like medical diagnostics and software have been excluded from protection here, but qualify for patent protection in Europe and China. These and many other challenges have led to the slipping stature of our IP system on the global stage and jeopardize long-term investments in research. I worry that China and other adversaries and competitors will exploit our system for their advantage. So I've worked hard on a variety of bills, bipartisan legislative proposals to address these concerns, and I will reference them today and look forward to exploring them with my ranking member and other members of this subcommittee. With Senator Tillis' cooperation, bless you, Senator, we've assembled a great panel with a diversity of views and perspectives to grapple with these and other issues. I'll introduce them shortly, but will now turn over to Senator Tillis for his opening statement. Senator.
Thank you, Chairman. It's good to get the band back together. I've enjoyed working with you on the Intellectual Property Subcommittee and alternating statuses as Chair and Ranking Member, and I'm very optimistic that we're going to pick up where we left off, and I look forward to that. I also want to thank my staff, the folks who do a lot of the work, have all the technical details, and especially and also your staff, because they've been great to work with. I'm looking forward to what we can accomplish in this current Congress, but I think we can be proud of what we've accomplished over the past several years together. And I would also like to thank Senator Leahy for the work that he did. A special thanks to Senator Hirono, Senator Hirono, I think you may actually have a perfect attendance record for IP subcommittee hearings. So, Senator Welch, that's an aspiration for you. But we do appreciate your engagement and the opportunity to work for us together. And Senator Welch, thank you for being here. Welcome to the subcommittee. Whether it's patents, trademarks, copyrights, or trade secrets, a strong, reliable, and predictable IP right is paramount to incentivizing U.S. innovation and creativity. Innovation and creativity fuel economic growth for our great country, and it has to be protected, and nurtured so that it continue to do so well in the future. Based on the USPTO's latest edition of their IP and U.S. economy report, an estimated 63 million U.S. jobs directly or indirectly relied on IP-intensive industries. And these industries accounted for nearly 41% of our GDP. Our purpose today is to explore the ways in which foreign adversaries threaten U.S. economic innovation, dominance through intellectual property theft and abuse. As the chair said, the most notable threat, of course, is the Chinese Communist Party. But to be clear, they're not the only foreign bad actor undermining U.S. intellectual property. In fact, I could cite a few, particularly in the IP space for pharmaceuticals and biotech, that some of our greatest friends and partners have disagreements on just exactly how far our IP protection should go. But the reality is China is the greatest violator of theft, and it has catapulted them into an economic powerhouse. I'm always reminded of what almost looks like a movie set of a pipe. It's called Charlotte Pipe in North Carolina. About a 100-year-old business. Foundry is very modern, but looks like the foundry when it was first established. You can go to a province in China and see what looks like a movie set. Charlotte Pipe. Stamped Charlotte Pipe on counterfeit goods or on, obviously counterfeit goods. That has to stop. A lot of their success is based on the innovation and the creativity of this nation. Their goal is to assume the title of as a global innovation leader, regardless of the methods employed. Methods such as theft, via espionage and counterfeiting, which cost the U.S. hundreds of billions of dollars each year. And beyond theft, a significant concern for all of us here today should be the CCP overtaking the United States in domestic innovation, rather than their current reliance on theft, using past theft to become a competitor head-to-head. We've got to do better. We've got to incent innovation, and I believe that the foundation or the bedrock for our success is making sure that we protect intellectual property rights. Given the urgency of the threat to the United States and our IP community, it is appropriate that we kick off the subcommittee with this topic. I'm happy once again to be working closely with the chair. I look forward to your testimony, and I do think there may be a vote, depending upon how long this committee goes, but we will continue to push forward. And Mr. Chair, I'm happy to either miss the vote or have the vote happen after the hearing so that we can hear all of your testimony. Thank you.
Terrific. Thank you. Thank you, Ranking Member Tillis. Would Chairman Durbin like to make a brief statement? You were fine, but thank you so much for joining us. And Senator Welch, welcome to the subcommittee.
I thought he was just taking roll. That's why I didn't thank him. Thank you, Chair.
We now will turn to our witness panel. Today we welcome 4 witnesses to testify to us about foreign competitive threats to American innovation and economic leadership. Our first witness, Mark Cohen, is Distinguished Senior Fellow and Director of the Asian IP Technology Project at the Berkeley Center for Law and Technology. Prior to teaching, Professor Cohen served as Senior Counsel to the U.S. Patent and Trademark Office and was the office's first attaché in China. Next, we have Patrick Kilbride, Senior Vice President of the Global Innovation Policy Center at the Chamber of Commerce. Mr. Kilbride oversees the center's multilateral and international programs promoting the enforcement and protection of IP rights. He served in the Bush administration as Deputy Assistant U.S. Trade Representative for Intergovernmental Affairs and Public Liaison. Next, we have Matthew Turpin. Mr. Turpin is a visiting fellow at the Hoover Institution and Senior Advisor at Palantir Technologies. He served at the U.S. National Security Council as the Director for China and Senior Advisor on China to the Secretary of Commerce under the previous administration. He also served in the Obama administration as an advisor on the People's Republic of China to the Chairman and Vice Chairman of the Joint Chiefs of Staff at the Pentagon. Last but certainly not least, we have Ms. Suzanne Harrison, founder and principal of Percipients, LLC, thank you, a board-level advisory firm focused on IP strategy management, on quantifying and mitigating IP risk. Ms. Harrison also serves as chair of the Patent Public Advisory Committee. Let me just briefly lay out mechanics. After we swear in the witnesses, each witness will have 5 minutes to provide their opening statement. Then we'll proceed to a first and possibly second round of questioning of 5 minutes each. And with that, if you would all stand, could you please raise your right hand? Do you swear or affirm that the testimony you're about to give before this committee will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Let the record reflect all swore in the affirmative. Mr. Cohen, you may proceed with your opening statement.
Thank you very much, Chairman Coons, Ranking Member Tillis, senators, and staff. It's a pleasure to be here today. Senators, China's rise did not occur overnight. Rather, we have made profound mistakes in not identifying China's increasing innovative capacity, and we need to proceed now without the bureaucratic myopia, antique organizational structures, and indifference to data that have haunted prior administrations, and we need to develop approaches that are in our long-range best interests. The needs are urgent. During the past 10 years, U.S. competitiveness in key technologies has eroded. Various studies based on such measures as patents, scientific publications, widely cited papers, or technology clusters have shown that China's capacity to innovate in many areas now exceeds the United States. I begin today my brief talk with some immediate steps. I follow this with two long-range issues, talent and transparency. In terms of immediate steps, there are three sub-issues: unfilled positions, self-strengthening our IP system, and the need for a whole of U.S. government approach. First, we need to fill the IPEC role. We should also establish a deputy U.S. PTO director for international affairs who could marshal the PTO's resources to better serve the interagency. There's also an important role for our Solicitor General and/or the PTO to educate our courts when they come into conflict with actions from Chinese courts. This role becomes more acute in light of China's stated goals of becoming a center for resolving international IP and commercial disputes, and it's reflected, I believe, in the Defend Courts Act from this committee. Second, we also need to clean up our own legal house. Our IP system has weakened as China has strengthened its own, often in the same precise areas. Here are several issues. One of them was just identified: creating stable and predictable eligibility outcomes, including fixing 101 issues. Another is addressing low-quality IP filings, particularly in trademarks from China. Another is to have China and other countries disclose government subsidies of U.S. PTO patent and trademark filings. And another is to develop better data-driven approaches to China's technological challenges. I also note that the TRIPS waiver extension for therapeutics and diagnostics should also be carefully considered if we're going to go forward on that. I personally oppose it. Third, we also need to create a whole of government approach to deal with these challenges. I would like to see a kind of task force of leading tech executives, academics, and officials with a broad mandate that could address the kind of multidisciplinary challenges that we face. And I should say, China doesn't say, let's infringe a U.S. patent. They say how we are going to acquire that technology. And that really demands a whole of government approach because it's interdisciplinary in nature. With my remaining time, I will focus on non-competes and transparency. A proposed FTC rule banning non-competes will make trade secrets much harder to enforce in local markets. Non-compete agreements give companies critical time to adjust to the possible loss of proprietary technology from employee mobility. They permit a company to protect its trade secrets without being forced to disclose it to judicial bodies. They are simply easier to enforce. Today in China, there's a 30% chance of winning a trade secret case. However, the odds change to 66% if a non-compete is involved. Why would we deprive our companies of a better and fairer chance to win a trade secret case? Professor Dennis Simon from UNC, testifying before Congress a few months ago, noted that Chinese employees in the semiconductor sector are often offered triple their salary in order to migrate to a competing company. And is this what we want with our CHIPS Act funding? That teams of US employees are poached by China or other countries, as has happened in California? Giving our companies the ability to staunch the poaching of tech talent is critical to our efforts to develop greater technological self-sufficiency. My final concern is transparency, particularly transparency of judicial decisions. I've been involved in this area my whole career. Yet if you ask me today if the Chinese judicial system is biased against foreigners, I could not comprehensively answer you. If you ask me if the Phase 1 agreement and its commitments to improve China's IP system, such as providing a patent linkage regime for pharmaceuticals, are being fully implemented, I could not answer you. Most of the cases are not published. I can answer you that based on available data and dozens of studies, that foreign parties do very well in IP litigation in China. But these studies are based on Chinese government curated databases. We need full transparency, not curated transparency. Part of the reason that China may not be living up to its commitments is that we have no way of monitoring China's implementation of them. Part of the responsibility for that also rests with us for not adequately prioritizing transparency. Thank you for your attention to these important issues.
Thank you very much, Professor Cohen, Mr. Cohen. Mr. Kilbride.
Thank you, Mr. Chairman, Senators. Appreciate it. We're here on behalf of the U.S. Chamber because we see the U.S. IP-based innovation ecosystem under duress. This is a multi-stakeholder ecosystem that more successfully than anyone else in the world advances knowledge and develops, tests, regulates, and delivers new technologies in a useful form to end users. The National Science Foundation has found that 3/4 of the R&D performed within this ecosystem comes from the private sector, an investment that relies on intellectual property rights backed by the rule of law. The IP is so critical because it enables those investments in long-term, high capital, high risk projects. It enables owners to assign a value to their intangible assets and enables them to engage in exchange of assets with other stakeholders within the ecosystem on mutually agreed and enforceable terms. And yet, this innovation ecosystem is under threat systemically in the multilateral level and in piecemeal national level attacks. It takes the form of online piracy, counterfeiting, trade secret theft, erosion of legal rights, forced technology transfer, political stigmatization of IP, and outright waiver of global IP commitments, creating an environment where American innovation and creativity is vulnerable. These threats come from every corner of the globe, certainly China, where forced technology transfer is part of the exercise, but also closer to home, where the EU Data Act, for instance, could force American companies to share trade secrets with governments and possibly even competitors. Here at home, we see self-inflicted wounds, such as U.S. support for the TRIPS waiver, the FTC non-competes attack that Professor Cohen mentioned, and the proliferation of abusive practices in third-party litigation financing that make the cost of prosecuting patents far more expensive. Americans are encountering these harms at home in the form of counterfeiting and piracy. The Chamber has studied this. The OECD has, finding illicit trade on the order of $500 billion each year, with obvious implications for health and safety, including cybersecurity and American jobs and growth. The businesses tell us if we can make it, they can fake it. It impacts everything, with some obvious, fake pharmaceuticals were mentioned, food, cosmetics, toys, medical equipment, and chemicals, for instance. In the COVID-19 pandemic, the increase in online shopping led fakes being delivered directly to Americans' front door in the form of small parcels, which exacerbates the enforcement challenge. The Chamber is working to address these challenges with our public sector partners through groundbreaking public-private partnerships, including an MOU signed with the U.S. Customs and Border Protection and a detailee project to the National IPR Center, where we're helping companies to share information directly with customs agents, HSI investigators, so that they can stop seizures from getting in, identify the bad actors, and prosecute the crimes. We believe a similar model could be applied in the streaming piracy space, and we're pursuing conversations with relevant agencies to that end. I want to thank Congress and the Senate for passage of the Informed Consumers Act in the last Congress, which brings important transparency to the e-commerce space. We see our members in those industries doing important work to do proactive vetting and monitoring of sellers, prosecuting of bad actors, cooperating with brand owners, and raising consumer awareness together with the Chamber. The streaming piracy threat, similarly to counterfeits, costing us 290,000 creative professional jobs in 2020, costing just those people $30 billion in revenue, but economy-wide up to 500,000 jobs and $115 billion in GDP, undermining a creative sector that employs 5 million Americans and provides nearly 12% of the U.S. economy. One of the challenges we have that makes our creative sector more vulnerable is that the U.S. government does not currently provide the tools to shut down foreign-based infringing websites. We can shut down U.S.-based websites and criminal and civil penalties apply, but we cannot do it for foreign-based infringement. We talked a lot about China, and obviously I think the scope of counterfeits from China is known to everyone. The chairman mentioned 80% of seizures at the U.S. border. With piracy, the challenge with China is more the market access barriers that prevent a legitimate market from providing access to consumers there. So creating a pirate market. We see rule by law instead of rule of law. This creates an environment of public policy risk that's anathema to investment and innovation and creativity. The Chamber has a new study on that, which I'd be happy to share with the committee. Thank you very much, Mr. Chairman.
Thank you, Mr. Kilbride. Mr. Turpin.
Chairman Coons, Ranking Member Tillis, and other members of the committee, thank you for inviting me today. While I'm a senior advisor at Palantir Technologies and a visiting fellow at Stanford's Hoover Institution, the views I express today are my own, and they're shaped by my last dozen years focused on U.S.-China policy during both the Obama and Trump administrations. A decade ago, Admiral Dennis Blair and Governor John Huntsman chaired the Commission on Theft of American Intellectual Property. Their work revealed that on an annual basis, the United States suffered approximately $300 billion in economic loss due to economic espionage, primarily by the People's Republic of China, along with the loss of millions of jobs. Over a decade, that's $3 trillion in losses. In 2017, the U.S. Trade Representative conducted an investigation under Section 301 of the Trade Act to examine whether the PRC government actions harm the United States. That investigation revealed 4 elements of Beijing's technology transfer regime. First, the use of opaque administrative processes, joint ventures, requirements, foreign ownership and limitations, and other mechanisms to require or pressure the transfer of valuable U.S. technology to the PRC. Second, the PRC government's actions and policies that deprive U.S. companies of the ability to set market-based terms in technology-related negotiations. Third, the government's direction and unfair facilitation of outbound and Chinese investment targeting U.S. companies and assets in key industry and technology sectors. And fourth, the PRC government conducts economic espionage using both human and cyber tradecraft, including the direct participation of PRC intelligence services like the Ministry for State Security. The IP Commission, the Section 301 investigation, and dozens of criminal prosecutions over multiple administrations expose a truth that many have found reluctant to acknowledge, that the United States is the victim of a comprehensive, intentional campaign by the PRC, which results in grave economic and national security harms. In many ways, the cost of these harms exceed the benefit that Americans gain from our economic relationship with China. This comprehensive state-sponsored campaign strikes at the very heart of our economy and the economies of our allies and endangers the qualitative military advantage that constitutes our deterrence against both Beijing and Moscow. Our economy, while broad and diverse, relies upon a foundation of innovation and technology leadership. That foundation reinforced by a constitutional and legal superstructure supervised by this committee that guarantees property rights and builds transparency, which incentivizes innovation and free markets over mercantilism and state control. Our legal and social structures create the environment for prosperity and innovation that is the envy of the world. Our national security is built upon a qualitative military advantage which offsets the quantitative and geographic advantages of our potential adversaries. This qualitative advantage persuades potential adversaries that the costs of military aggression will far exceed the benefits that they could gain. To create this qualitative military advantage, the U.S. military relies upon unequal access to the technological advantages generated by our innovation economy. The Chinese Communist Party is attacking this dynamic economic and national security system with its comprehensive campaign of forced technology transfer and economic espionage. Beijing abuses its access to the globalized economic system to undermine the United States and other open societies. As this subcommittee well knows, the United States has extensive layers of protection. Dedicated and hardworking Americans across departments and agencies work every day to protect us from this hostile campaign. Unfortunately, the PRC adapts its strategy and tactics to exploit gaps and seams in our protective layers more rapidly than we can adapt. Additionally, PRC entities acting at the direction of the PRC government weaponize the U.S. legal system in ways that are against the interests of Americans. And to date, we have been relatively little to impose costs on those PRC entities that benefit from this campaign. The United States must consider a shift to holding the PRC and its commercial entities collectively responsible. Episodic and uncoordinated responses by individual departments and agencies, no matter how well-meaning, are no longer sufficient. I have 4 recommendations. First, identify the beneficiaries of IP theft, forced technology transfer, and economic espionage. Second, enable closer coordination across the U.S. government and the private sector to understand the tactics and techniques that the PRC uses. Third, compel corporate and other private sector victims to be transparent about IP theft and other forced technology transfer requirements. And fourth, stop the importation of goods produced with or which benefits from this harmful campaign. Chairman Coons, Ranking Member Tillis, other members of the committee, thank you for this opportunity to testify. I look forward to addressing your questions.
Mr. Turpin, thank you for your testimony. Ms. Harrison.
Chairman Coons, Ranking Member Tillis, Senators, it's an honor to discuss 3 ways this committee can utilize IP to ensure our national security and increase our economic competitiveness. I'm here testifying in my personal capacity, and all the views and opinions expressed today are my own. My background is in executive corporate management with emphasis in strategy, finance, and organizational behavior. I've spent the last 30 years advising multinational corporations, small companies, inventors, and patent offices around the world how to use IP to increase value for organizations and economies. I have created, defined, and benchmarked best practices for intellectual property management, and I've written 3 seminal books on the subject. Many of the strategies that you see nation states employing were learned by watching how companies deal with their competitors. I am currently the chair of the USPTO PPAC, where we submit a report to Congress and the White House every year with our view of what is happening in the USPTO and the IP ecosystem, along with recommendations for both the USPTO and Congress on how to improve the IP system. In 2020, with co-authors Gene Sochodolsky and Bowman Hayden, we identified that the Chinese government is currently utilizing a competitive strategy, which is a systematic and coordinated effort to achieve technical and economic dominance through both legal and illegal means to misappropriate U.S. technology, undermine our innovation ecosystem, economic stability, and national security. We name this Chinese strategy innovation warfare. The U.S. needs an effective counter-strategy to address this new competitive threat. IP is the newest tool in our comprehensive defense toolbox, and we must do a better job of utilizing it to keep our country safe and grow our economy. I would now like to discuss the 3 ways this committee can help. First, create and disseminate a new IP narrative. For the past 17 years, the narrative around IP has focused on optimizing the IP system for one set of industries over another. This ultimately led to the formation and implementation of PTAB at the USPTO. Unfortunately, this also led to a lack of public confidence with the USPTO, as this set up a false and damaging narrative that either the USPTO examiners were granting patents that should not have been granted, or that PTAB judges were invalidating patents that were rightfully granted. Redirecting that narrative is necessary to strengthen public perception of IP. Describing how IP can help the nation economically, technologically, and as a vital part of our national security strategy is needed. 2, shore up our IP ecosystem. In the Innovation Warfare paper, we discuss using patents as technology control positions. The concept of a technology control position only works if patents can actually exclude. Over the past 17 years, the Supreme Court has significantly eroded the ability of a patent to exclude others. Congress needs to restore this fundamental right and reduce ambiguity created by the judiciary across the IP ecosystem in areas such as obviousness, eligibility, claim construction, damages, and more. This time, Congress should account for the role of IP in maintaining economic and technological competitiveness and optimize the system in ways which allow for different industries to use and value patents differently. Successfully growing our economy requires all industries to utilize IP in ways that are advantageous to their growth. Finally, clearly define the leadership role of the USPTO in this new environment. While it is true that the Defense Department has the statutory authority to keep our nation safe, the needed expertise to bring this counter-strategy to fruition is scattered widely across multiple agencies, as our panelists here today can attest. The USPTO has data that can be useful to enable other agencies to visualize these new and emerging battlefields and feed into a predictive forecasting model, such as future-oriented technology analysis. This committee should work with Director Vidal to define and authorize the USPTO's role in working with the DoD on FTA matters, specifically, and on a counter-strategy more broadly. I'd like to conclude my remarks by briefly reflecting on what the other witnesses have shared. Data matters a lot, and we need more of it, and we need to use it more consistently. We need a defined, holistic strategy and not incremental changes to our IP system, which requires a different way of thinking about this problem. Our freedoms and values that are embedded in our legal system are at stake, and we are under attack. That needs to be thought through very carefully. Thank you for your attention, and I look forward to answering any questions you may have.
Thank you, Ms. Harrison. Thank you, all four of you, for your thoughtful testimony. I appreciate the various perspectives you've brought to bear about foreign threats to American IP and potential ways to counter them. I'll start my questioning by exploring China's plans to become an innovation superpower and the illegal methods they're using to advance their goals. And if we run out of time in this round, I'll likely take a second to explore how we can strengthen our IP system. Professor Cohen, if I might start with you. In 2015, the Chinese government announced its Made in China 2025 initiative, which identified key industries and technologies for which it hoped to supplant U.S. global leadership. Can you briefly explain China's strategic IP plans and how you expect their strategy to evolve in the coming years?
Yeah, it's a great question, and it could be the subject of many hearings unto itself. I think most Americans, most individuals from market economies would be shocked at the level of industrial policy planning that goes behind not only manufacturing, but innovation, and more specifically, intellectual property. So in addition to Made in China 2025, we have the National IP Strategy, which is usually in 10-year increments. And we also have local and national ministerial level policies governing IP innovation, manufacturing, and related areas. Most of these are in the concerning areas are in sectors that we would consider strategic or emerging industries: robotics, AI, 5G, 6G, high-tech, genomics, advanced manufacturing techniques, et cetera. In many cases, they seek some degree of dominance. Sometimes it's measured in terms of patents or technology or exports or talent. And talent programming is also a significant part of these industrial policies. I don't know any counterpart to that in the United States about how to develop talent through the universities or even bringing in foreign talent. And that feeds into a lot of these national talent concerns that the FBI and our police agencies have problems with, luring talented professors, corporate officials, technologists to China to help China advance its economy. My own belief is a lot of what happens in China that is nefarious is not so much government mandated, but government inspired. There's a difference. If China wants to acquire technology, it will do it at the lowest cost with the least publicity possible. And in many cases, that means that individuals want to try to satisfy these mandates in order to get incentives, subsidies, promotion, recognition. And that feeds into really a vast plan to increase innovative capacity and technological and national security capacity in a wide range of sectors.
Thank you. Mr. Kilbride, if I might, just the economic impact of online piracy and counterfeiting interests me. It's been reported 4/5 of the U.S. population shops online. Nearly all of us do. And a significant proportion of the counterfeit markets move to online. Have e-commerce platforms provided effective initiatives to assist in identifying and removing counterfeit products, the majority of which are coming from China?
Thank you, Mr. Chairman. Great question, and the answer is it's a mixed bag. Some are doing better than others. We see some real best practices, and we're working to benchmark those. They include some of the steps that I mentioned in my testimony, including very significant work to proactively vet, sellers, which is assisted by passage of the Informed Consumers Act, but also proactive steps on behalf of the industry. We see some companies investing in units that enable them to use their own data to share with prosecutors and essentially hand over cases ready to prosecute when they've identified bad actor networks. And we see much more cooperation with brand owners. That's been a real improvement, but obviously there's more work to be done.
Well, thank you. The Informed Consumers Act was an important step forward, Mr. Chairman. I'll mention that I have also worked with Senator Tillis on the Shop Safe Act that would hold platforms liable for the sales of harmful counterfeits unless they've adopted a set of best practices for evaluating sellers and products. Mr. Turpin, if I might, briefly, and then in the next round I'll come to you, Ms. Harrison. Trade secret and IP theft through economic espionage disadvantage our companies, our national security, our global competitiveness. I'm concerned we're not doing enough to counter this theft, to impose costs on the beneficiaries. That's why I've worked on the Secrets Act with Senator Cohen to help prevent goods made with stolen trade secrets from entering our market. Do you agree that preventing goods from being imported to the U.S. would help deter state-encouraged or state-sponsored IP theft?
Mr. Chairman, thank you. Absolutely. I think without the perception of a significant cost, it is unlikely that we would see a change in behavior, right? So fundamentally, we would need to see the imposition of costs, and that would mean that they don't gain access to this market for them to begin to view that largely this illegal behavior is not beneficial to them, and to even for them to even comprehend changing their behavior and doing something else.
So finding some way to impose sustained costs on the beneficiaries of IP theft is something I suspect all of you would recommend. Let me defer now to my ranking member, Senator Tillis.
Again, thank you all for being here and the time you took to prepare for the hearing. I think Mr. Cohen and Ms. Harrison, you touched on it, particularly based on your professional history. But if you're an early stage innovator and you have uncertainty, or you define a fairly short period for protection of your IP rights, what does that do to innovation at that level of the ecosystem? I mean, it would seem to me that it would make it very difficult for some of these innovators to even get some of the funding that they would need to move forward. Do you agree?
I guess I'll go ahead and take that.
We'll go in reverse order.
The answer is it depends. Right now, there are certain industries where there are a few patents to a product, pharmaceuticals, chemicals, where you are required to have a patent before you'll get funding. But in high tech in particular, investors are in and out so quick, they're not around long enough for the patent to take place, and so they don't require it. And most small inventors aren't bothering to get it, not recognizing that it could be helpful.
The downstream risk.
Yeah, it's not a tool that is currently helpful in their toolbox.
Okay.
And the technology is moving so fast.
If I may add, instability and duration are important concerns in the U.S. system. Certainly, one-on-one instability has been a concern, I think, in driving capital and new enterprise formation. I would also note that the U.S. system, the IP system, particularly patent filings, tend to be highly corporatized. Oddly enough, even though we think of China Inc., China has a larger cohort of small inventors, both as a percentage and in absolute terms, than the United States. I think if you lined up the individual inventors in China, they would be greater than the total number of applicants at the USPTO in a given year. So how do you incentivize those smaller enterprises to create and develop high-quality IP is a really important issue for the future of this economy.
I could, Ms. Harrison, I think you did a good job of explaining at this early stage are new innovators. But I can tell you that the lack of certainty and the risk of having your IP rights stripped has an absolute chilling effect on businesses. It has a chilling effect on innovation. And you all, at least two of you, maybe three, mentioned TRIPS waivers. That, to me, I want to hear from someone who thinks that TRIPS waivers are a good idea. But I can tell you, congressional action here, there's a direct map between congressional action and a dramatic reduction in research in the very space that we own a leadership position, that's in life sciences, biotech, pharma. We've seen actions in this Congress that has had a direct, measurable impact on small molecule research, for example. Really the holy grail for some of the most challenging diseases that American citizens are experiencing. And I think the TRIPS waiver is a bad policy. Is there anybody on the panel who thinks that there's a good version of a TRIPS waiver? All right. Happy with that answer. How big of a threat do you see China's involvement with standard essential patents, SEPs, especially in light of their connection to critical international technical standards such as 5G? We'll start with you, Mr. Cohen. Your speaker may be off. Red means that it's on.
Got it. Sorry about that. Much as China subsidizes patent filings, it also subsidizes participation in standardization bodies. And certainly China has also had goals to minimize its outpayments and royalties, although some companies like Huawei are starting to also receive royalties, so that's changing a little bit. But for a very long time, I would say over 20 years, China has sensed that it has to, dominate standard-setting bodies, file as many patents in these bodies as possible, reduce outbound royalty payments, and drive the narrative. And I think in some areas they've succeeded, or at least they've certainly increased their presence. And we also have the threat of litigating in China and the possibility of anti-suit injunctions. That threat has diminished in recent years, but it is a real problem for companies that could risk forfeiting their China market or their ability to license in China.
Anything to add, Mr. Turpin?
Yes, Senator. I think one of the critical points to keep in mind is that standard essential patents essentially form the operating system of how our world works. And fundamentally, the values, norms, and processes of how our international system will work and all of our technical standards are going to be set by certain ways in which companies approach them. And certainly I think the PRC views an open, democratic, transparent international system is something that they would want to adjust in the direction that is more fitting of their authoritarian model, right? And therefore use those standard essential patents to
more closed and opaque.
Correct. That's how they see it. And so I think that is, there's very much a very political aspect of their involvement in this.
Well, thank you all. I'm going to ask a few other questions. And the good news for you all is I love your testimony. The bad news is I've got a lot of questions for the record. Thank you, Mr. Chair.
Thank you, Senator Tillis. Senator Durbin. Chairman Durbin.
Thanks. It's an honor to be here, and thank your committee for its good work on a very important topic. The Inform Act was the result of a conversation I had 10 years ago with Home Depot, who said they're selling our own home drills, the drills that we make just for our customers, on the internet in volume. They are either stolen or counterfeit. They've got to be one of the two. We only make them in China and sell them in the United States. Well, you'd think if they were stolen or counterfeit, the vendor would like to know that too. They didn't want to hear anything about it, and they refused to identify the source of that drill being sold on the internet. It took us 10 years to create a law, which we finally passed in December, which moves us in the right direction. Bill Cassidy was my co-sponsor on it. But it's an indication of what we have faced in the past and what American businesses have faced in the past. 4 minutes left, not enough time to ask, let alone ask and answer the questions I have here, but I'll throw a few of them out there. First one, are any other countries of the world engaging in economic espionage? Maybe you can think about that for a second. Please identify them if you know them. Second, what is the impact of artificial intelligence on intellectual property? What is going to happen as we venture into this brave new world of AI and the information gathering that it's capable of? Third, did anybody read Tom Friedman's article in the New York Times over the weekend on China? Please do. He went to the largest chip manufacturer in the world and the most respected in Taiwan and said, why are you different? Why across the Taiwan Straits aren't the Chinese producing similar products? And the owner of the company said one word: trust. Businesses come to us and believe they can trust us to follow through with their assignment, whatever it happens to be, without compromising the integrity of their own property rights to that information. Trust. And they don't have it in China. Which brings me to the final question. As I step back and try to reflect on the fact that we are just 50 years, a little over 50 years beyond ping-pong diplomacy, I'm trying to figure out what the hell happened in Red China. Red China, we used to call it. Now we call it the Chinese Communist Party. What happened there? This wasn't supposed to happen. Not a market economy, not a democratic nation, and yet they are competing with us. Did they mandate innovation? Did they steal innovation? Is there something else going on there? What is happening in China now that makes them so competitive with the United States when they apparently have so many obstacles to overcome in an authoritarian government, non-market economy, and dealing with a democracy like our own and a capitalist economy? Just a few questions, and anybody who can be interested can tackle them.
Thank you. And Mr. Chairman, you'll be pleased to know we're going to have an entire hearing on the impact of artificial intelligence on patents and innovation. But please take your time and answer Chairman Durbin's question.
So Chairman, maybe I'll take the first one and the last one real quick. On the first one, I think it's pretty clear that the lion's share of it, of economic espionage, as defined as a state actor pursuing it, is being conducted by the PRC. There are probably other examples, but in many ways those are quite minimal. And then sort of what happened. I think fundamentally our strategy of using economic engagement to drive political liberalization absolutely scared the Chinese Communist Party. And so for them to adopt the kinds of things that we would expect to be a responsible stakeholder in a liberal, rules-based international system would undermine their rule. And so they have chosen to compete in a very different way. And that's the path, unfortunately, that we're down. I think we are on a pathway to a much more turbulent relationship with the PRC than even if we see now.
If I may, Leader Durbin, thank you again for Inform. Extremely important. Its application both to organized retail crime and the threat of counterfeits is really going to have an impact. We're looking forward to monitoring how it's being implemented by the June deadline and working with companies to share best practices in that space. In terms of, I'd like to speak to your question about AI. I think, initially we're going to see a real threat to our system in terms of rampant infringement. And ultimately, I would go on a limb to predict that we're going to see AI potentially become a savior of our system because it's going to give us the technological tools to tackle some of the challenges that Ms. Harrison outlined that are extremely important in terms of being able to manage IP rights at the speed and scale that's necessary to reflect the technologies that we have today.
If anybody else wants to comment on the chairman's questions, please feel free.
I'd like to comment briefly, Mr. Chairman. A few points on this trust and what we missed with China. I think Taiwan is a unique model because of the fabless manufacturing for semiconductors that takes place there. That makes Taiwan a significantly large importer of U.S. technology that they pay for, or that is used to produce semiconductors on demand for manufacturers. So to do that, you have to have a legal system that you can rely upon, that trade secrets won't be stolen. By the way, there is a lot of trade secret theft intermediated through Taiwan, but Taiwan has a decent enough legal system to handle it. So it's really a unique example of how you can develop a good IP system using licensing and technology and cooperation with the rest of the world, especially the United States. China is not a good example of that. Historically, China was a highly under-licensed environment. Actually, China paid about as much for technology as Taiwan did in a given year just a few years ago. I think one of the reasons we went astray with China is we relied a lot on platitudes, frankly. We assumed too much. We assumed that the internet would create democratic and open societies. That was not true. It can equally be used as a tool of repression. We assumed that when a country begins to own IP, it would protect IP for everybody. And this goes back to the question that Ranking Member Tillis raised about China, which was that in a state-controlled economy, it's not necessarily true that improving IP will necessarily raise all the boats. It may only affect the domestic participants or favor them over the foreign participants. So I think there are a lot of things that I think we missed the boat on simply because we applied general perceptions of the rest of the world, of market-oriented economies, applied them to China, and we found that it really did not quite work the way we anticipated. At least that's my observation.
I would just add on to Mark's comments that we cannot use history to predict the future, and that's what we did with the Chinese IP system. Because every other country, when they created an IP system, followed the same predictable steps, and we expected China to do that, and they did not. But what we can do is we have data. We have a lot of it. The USPTO has an immense amount of patent data, and we can actually begin to predict where the technology battles are going to be in the future. And rather than deal with them today when we don't have very many tools in our toolbox, we can anticipate where they're going to be when we have time to make changes and actually stop the issue before it happens. And that's what this future technology-oriented analysis type of technology can do. We are not leading in that technology. Actually, South Korea invented it. China is currently utilizing it and giving it to all of their companies. We do not. It is not clear where in the United States DoD system that's being created. It's certainly not using patent data to predict those technology battles. We need to do a better job of taking the data we have and utilizing it in ways that we need to do.
Fascinating. Thank you all. Thank you to the members of the panel. Ms. Harrison, if I might just follow up on what Senator Tillis was asking, and on, I think, something implicit in what Chairman Durbin was just asking. How do we strengthen U.S. leadership in standard-setting bodies? Standard essential patents and standard-setting bodies are critical, and foreign governments have taken a stronger and stronger role in this, in particular Chinese. How do we strengthen the United States' role in standard setting?
I think there are a few ways that we could actually do that. The first thing is I think we are naive and thinking that people that show up at standard-setting bodies are the people who we think they are. There's a real party and interest issue. We have nation states packing the panels, packing what's being said in the voting, and we don't know, nor do we understand who people are really representing. That's something that needs to change. Two, I think that we have a very hands-off approach to standard-setting bodies. That is not something that we've always done in our history. We've taken a more hands-on approach in prior administrations, and I think we need to reconsider what that actually means. And I think we really need to focus on ensuring that many of the activities that nation states deal with in terms of standard-setting bodies happen outside of the body. There are special meetings held in their own countries, packed with people that they know will vote the way they want, and those are used as precursors of opinions or guidance that come into the bodies. Again, I think we need to really be careful of how that's happening and pay attention to that.
Let me follow up on one other thing you mentioned about standing. I'm concerned that a country like China that has a coordinated, focused, nationally funded IP strategy can exploit the fact that there's no standing requirement in inter partes review and PTAB, to swamp it with basically unlimited resources, flood the PTAB with attacks on U.S. patents in the same way they've been flooding the PTO with patent applications. To counter this threat, would you support a standing requirement or limits on the number of PTAB petitions per patent that a particular party could file?
Thank you for the question. So I think that standing is an important query, as is real party and interest. I believe that that is the type of ambiguity that is a legal means which Chinese government and others exploit within our current systems. Yes, I would encourage a standing requirement. I also think in terms of going back to the IP narrative, why is it fair to allow people with no standing to bring suits against patent owners? That just is an equitable problem, and I think that is what the kinds of things that are having inventors lose faith with our system, and that's not what we want. We want our system to be fair and equitable.
Professor Cohen, if I might, you referenced the critical issue around transparency, there being only curated insights into the outcome of litigation in China. You, in fact, cited lack of transparency as the most important reason. We know so little, really, about how China's IP system works. And you describe that as the biggest missing tool in our IP arsenal against China. What could we do to ensure that China increases transparency so right holders can actually protect their interests and so we can make better informed policy decisions?
Well, there are a number of tools. I think, frankly, one of them is the WTO. The TRIPS agreement says that cases of general application and final judicial decisions should be published. And the U.S. brought a case in 2007, which we didn't quite see to completion. We should have, I think, appealed that case, where we were trying to compel China to publish all cases since it had joined the WTO in 2001. So I actually think the WTO has an important role here. China does publish a lot of cases. Cases are sometimes removed from the database for political or other reasons. And there are efforts among academics to try to track that. The cases themselves do provide insights. So it's not to be totally discounted. It's widely used. I think there's something like 140 million legal documents on the official China database right now. And there's well over, I forgot the exact number, but it's billions of page views. I mean, perhaps over 100 billion of page views that since the database was set up. So the database can be mined, and there are useful observations that come from it. I mentioned that non-compete agreements have a 66% chance of success, trade secrets 30%. That's drawn from that database. So even if it's curated, there's useful information to abstract from it. And I think at such time as we begin to have dialogue again with China, we should be working individually and with our partners, trading partners, to insist on greater disclosure. It's not what makes China look good that matters in that database. Frankly, it's the exact opposite. And this goes against China's own inclinations to use cases as kind of a propaganda tool.
Understood. Thank you, Professor. Senator Tillis.
Thank you, Chairman. I wanted to come back to the non-competes as well. I think if you were to eliminate those, you would open a wide door of intellectual property theft. You would go away from maybe somebody that works for a firm for some number of years, decides to move. Maybe they wade into a violation of their non-compete, but you'll have a whole cadre of people that will go work somewhere until such time they have the trade secret and they move on. I mean, that to me is about as obvious as the bad policy of the TRIPS waiver. I may have mentioned that before. But approximately 80% of all espionage prosecutions brought by the DOJ allege conduct that would benefit the Chinese state, and approximately 60%, so 80% would benefit the Chinese state, 60% of all trade secret cases involve China. What steps can the DOJ do with the current tools that they have, or what more do we need to do to enable them to address this challenge, if you agree that it is a critical issue?
I believe, and I'm sure Mr. Turpin also has some observations, but let me just share my own observations from the time I was at the PTO. I think that the FBI and the other law enforcement and science and technology institutions of the government should have a much more risk-based approach to technology misappropriation. China publishes its industrial policies. We know what areas are targeted. We can even break it down sometimes by patent classification or subcategory of technology. And I think focusing on those areas, and that would also mean not only bringing cases, but educating our companies that they're under threat if they don't already know it, has to be a big part of the toolbox. I doubt we can stop all trade secret misappropriation or IP theft, but we should really address it in areas that are of core critical concern to us.
Yeah, but if you want to open the door, I'm sorry, go ahead, Mr. Turpin.
Yes, Senator. I think the DOJ obviously cannot be the sole entity that seeks to go after these things. There has to be a degree of linkage across other.
I heard the whole of government, I think, from Mr. Right. I think that's critically important.
Absolutely. I mean, it's so understanding that you may not be able to essentially prove it in court because largely the PRC government is going to prevent you from having the transparency that allow you to do that. But of course, that isn't the bar that you have to cross to use other authorities and other departments, right? So the Commerce Department has its own authorities to be able to put sanctions on activities. The Treasury Department has, and in this sense, the executive branch has to actually work together to pursue these things, as opposed to viewing an intellectual property or an economic espionage case as solely just something that is the purview of the Justice Department.
Thank you all. I see that Senator Padilla is here, so I'm going to live up to my promise of sending questions for the record, but I'd also like to reserve the right to maybe schedule some time to speak with you all in my office or over the phone, whatever is most convenient for you. Thank you, Mr. Chair.
Thank you, Senator Tillis. Senator Padilla.
Thank you, Mr. Chair. Senator Tillis, if you would have taken a few more minutes, and I would have had more time to ask more questions as
I'm
well.
happy to ask another question,
I'll
too.
do some follow-up in writing. Good afternoon. Let me begin by thanking Chairman Coons for holding this hearing. We're here to speak about foreign threats to American innovation. But I'd be remiss if I didn't acknowledge a couple of areas where we're actually doing harm to ourselves. First, we need to do more to ensure that our innovation ecosystem is welcoming and reflective of the creative capabilities of all of our communities, even within the United States. There are some communities, some populations that are very active and represented in innovation, and others that we have, by a long shot, not begun to tap the talent, the creativity, and future expertise and leadership. We also need an immigration system that allows us to much more effectively not just recruit talent, but retain talent. And that may be a worthwhile topic for a hearing another day. I do want to jump into a specific item that I don't think gets as much attention as it deserves, and that's our efforts to fully understand the avenues that nation-state actors are using to take advantage of patents and our legal system. I think it's essential to identifying systemic vulnerabilities. For example, it can be difficult to identify the direct financial interests at play in patent infringement litigation. What do I mean by that? Well, let me just say I'm concerned that the funding obfuscation may be shielding nation-state conduct that is meant to harass American firms or attempt to force the disclosure of sensitive information. So let's start with Professor Cohen. Do we know whether or how much, not just the Chinese government, but any foreign government for that matter, funds or subsidizes patent infringement litigation against American firms?
Thank you, Senator. If I may back up a little bit, I think we don't even know how much foreign ownership and investment there is in our patent and trademark applications. So the underlying rights themselves are not identified if there's a government subsidy or support. We do require that in Bayh-Dole. If there is a U.S. government-funded patent application, then that would be disclosed and available on the PTO database. That does not apply to foreign applicants. So I also think this is particularly critical. It's caused a lot of disruption in the PTO with government government subsidies from China of trademark applications, and I think a disclosure requirement could be immensely helpful, at least in identifying the magnitude of the risk. I do not think we have that data available for government-funded or subsidized patent assertion entities, whether they're from China or elsewhere. And I think that would also be useful, again, in determining the risk, although I doubt that private entities have to disclose the nature of their investors either. I would like to begin really with the right themselves, personally. I think that's a very high priority because patents, as you mentioned, can be an agent of influence in our system, and right now there is no disclosure requirement.
All right, so it sounds like you do agree that it would be helpful,
yes,
valuable to have this information. And if so, any other ideas or recommendations that you would urge Congress to consider?
I think disclosure of Chinese or foreign government investment or support for the underlying research or the application itself, if it's a patent or trademark, will be extremely useful.
Okay. Mr. Kilbride, you seem eager to add here.
Thank you, Senator. I would just agree that we're concerned about the problem. In my case, I'll refer to foreign investment in U.S. litigation, so problem of third-party litigation financing. And while we don't have good numbers to attach to that, I think there's an increasing anecdotal body of evidence that we need to get our hands around it.
Okay. And if the chair would indulge me, I'd like to add just one more question, and that's regarding economic espionage and trade secret theft. This is something that Senator Tillis raised a few minutes ago. The Department of Justice last year announced a shift from its earlier China initiative to a broader strategy for countering nation-state threats. In announcing that change, Assistant Attorney General Olson cited both concerns about threats from other countries, including Russia, Iran, North Korea, as well as concerns from the civil rights community that the China initiative fueled a narrative of intolerance and bias. At the same time, he stated the government of China stands apart in threatening U.S. security through its concerted use of espionage, theft of trade secrets, and other tactics to advance its interests. What policy approaches would enable Congress to try to prevent foreign entities from gaining too much access to U.S. intellectual property and technical know-how while still fostering beneficial international research and business collaborations? And again, we'll start with Professor Cohen.
Research integrity is a critical issue, particularly vis-a-vis China. I think in the past it had not, inadequate attention had been paid to that, and that includes not only the ongoing research itself, but the follow-up research. An example of that is China permits the filing of patents anonymously. So in some cases, a trade secret could be misappropriated, and then the misappropriator can take it to China, file a patent anonymously, and the underlying technology is thereby disclosed. Sort of a double whammy. You own the technology that you've stolen, and it's publicly disclosed. So there are some issues we really do need to take up with China in terms of the environment, which sometimes does not foster legitimate technology cooperation. We had some improvements. We brought a WTO case on China's technology transfer rules, which discriminated against foreigners. But a lot of the integrity issues are really going to be left to the universities and companies that undertake them, and imposing higher standards, including best practices for separating out of technology, who gets cooperated, vetting of parties we collaborate with. China is leading the way in many areas is leading laboratories and other facilities. So not engaging with China in certain areas could impair our technological competitiveness and has to be factored in as well.
Thank you very much. Thank you, Mr. Chair.
And thank you, Senator Padilla. Senator Hirono?
Thank you very much, Mr. Chairman. Thank you for convening this panel and holding this hearing. Our IP system has long been the engine that drives American leadership and innovation, and we must ensure that our system encourages American innovation and does not allow bad actors to stifle or steal it. Unfortunately, we know that some of the bad actors, at the head of that list is the Chinese government, as we have heard today. It is important to deter Chinese government wrongdoing and prosecute espionage and theft, but our concern is with the Chinese government and not with Chinese people And we must avoid misguided prosecutions like some of those undertaken by the previous administrations in their China initiative. Going after professors on shoddy evidence will hurt, not help American innovation, by sending the best minds elsewhere. Indeed, expanding the pool of innovators can only grow our economy, which is why I have sponsored the IDEA Act, which many of my colleagues here have joined in on, that would, on a volunteer basis, have the information that goes to who is actually applying for patents in our country. And I do acknowledge, and I thank the panelists and my colleagues also for acknowledging that there is a distinction that needs to be made against what the Chinese government is doing and not create a situation where Chinese people come under assaults and attack, not to mention prosecution under the so-called China initiative. So thank you, Mr. Chairman. The Chinese government, this is for all of the panelists, has undertaken a widespread and systematic campaign of stealing American intellectual property to advance the Chinese economy. The Justice Department has initiated a number of prosecutions, some warranted and some misguided. As I mentioned, what proactive steps should our government agencies be taking to protect American intellectual property and businesses? I know that you have noticed some things, but what is the one thing that we ought to be doing? We'll just go down the list. Anyone who wants, for all the panel.
Well, Senator, I'd say identify the ultimate beneficiaries of economic espionage and IP theft, as opposed to focusing solely on those who might have been caught up in the conduct. But all too often, the benefits of that theft go back into a Chinese state-owned enterprise or within a Chinese entity, and then they gain significant material benefit from that theft. And we don't do enough to transfer costs onto those entities. And largely, I think they then conclude that this is an effective strategy, right? That there is only minimal cost, and it's often paid by third parties, and they benefit from this activity.
So you're basically saying it is the Chinese government itself, or certainly an entity that is supported by the Chinese government, that is the beneficiaries. Do the rest of the panelists agree that that is a very critical thing that we ought to identify and somehow impose some costs basically onto the Chinese government? Do you agree with that?
I'll go ahead. Thank you, Senator. I think it's important that the U.S. government use the tools that are at its disposal. Some of those include imposing costs when bad actors from any source, infringe our intellectual property. But I think what's most important to your initial question is that we get the system right at home. And I think we're very concerned that there's been a sort of political shift and that IP has become out of fashion all of a sudden. And that's very alarming. I think Ms. Harrison put it very well in her testimony that you've got this conflict between whether good patents are coming out of the USPTO or the PTAB has it all wrong. And until we can resolve that, we're going to have a real dilemma in the United States. So I think it's critical that we restore the foundations of our own IP system that's going to do more than anything that we can impose on foreign actors.
Yes.
Thank you, Senator. I tend to agree with Mr. Kilbride's perspective. I think the first place to clean up is our home because it's more under control, it's more transparent. We know how to adjust it and titrate it as best we can. I think that utilization of the U.S. and even the Chinese system by small businesses in the U.S. is extremely low. And I think that contributes to a very large sense of frustration in that community. Sometimes they have no presence in China, but they're affected by counterfeits or pirated goods coming into this market or into third markets. So with no revenue coming in, you don't have the resources to fight it. And I think having low-cost mechanisms in the U.S. for small businesses to address infringement and to utilize the low-cost methods that exist in China, because actually China has very inexpensive methods of protecting IP. If they fail to have government resources to support them. I'm a little worried about systems that say that we'll impose certain costs on China, because who's going to adjudicate that in the U.S.?
The question of jurisdiction comes to mind.
Yeah.
Thank you. Ms. Harrison, would you like to add? Do you
Yeah.
mind, Mr. Chairman?
I was just going to say, I think that we should be focusing on our IP system because it increases our GDP first and foremost, right? Let's get our own house in order to make sure our numbers and our economy and our technology competitiveness are robust. So I think we really need to talk about how IP affects GDP. The USPTO recently came out with some numbers from Professor Lisa Cook that said if we quadruple the number of inventors and we bring those inventions to market, we could increase GDP 4.5%. That is a very large number. That's like $1 trillion. And if we could add that to our economy, that's a massive engine of growth. So first and foremost, get our own house in order. Secondly, companies are unwilling foot soldiers in this battle. They're the ones who are having to deal with nation states. No company will ever win against a nation state. They do not have enough resources, they do not have enough money, no know-how. So one of the questions should be, knowing that nation states are taking advantage of our companies, what mechanisms can we provide them to help them win that battle? Also, we have not told companies this is happening, that there's a defined, concerted effort by the Chinese government to go after them. So how do we expect them to be prepared? How can they know when they see certain activities in a marketplace, whether that's a competitor company or whether that's a nation state? We must message this to them. We must give them tools. We must give them data. We must help them. We have no plan. We need to get one.
Thank you. Just one more thing, Mr. Chairman. I would like to ask unanimous consent to enter into the record an op-ed that was written by Holly Fechner, who is the executive director of Invent Together, wherein the title is "To Understand Why America's Lead in Tech is Eroding, Look at China's Investment in Women Inventors." And that is very much along the lines of Ms. Harrison.
Thank you, Senator Hirono. Without objection, it will be entered into the record. Senator Blackburn.
And thank you, Mr. Chairman, and thank you all for your patience as we have all been up and down and back and forth today during this hearing. But as a Tennessean, this is a very important hearing to us, protecting against infringement and IP theft from the CCP and from Chinese companies. And see, we see it not only in music, which the music industry loses about $12.5 billion a year because of this, but concert merchandise, a sport team merchandise, you see it in guitars, you see it in aftermarket auto parts, and in some of the patents that are held for new eco-friendly automobile engines and different things. So it is a frustration. And I think one of the things, and I'm glad that Senator Hirono mentioned the PTAB process, because this is frustrating to see companies like ByteDance with TikTok using PTAB, seeing Huawei, ZTE using PTAB, and filing their complaints. And Ms. Harrison, you touched on this with getting things in order and strengthening our process. So I'd like to start with you. If you were sitting here and you said, these are the things that we need to do because this is costing us billions and billions, tens of billions of dollars every single year. So what are the three things that you would first and foremost do?
Thank you very much for that question, Senator. I think the first thing I would do is that I would ensure that every government agency that deals with IP in the government has the same view and is employing the same yardstick to measure success.
So
which is
consistency
across all agencies.
Okay.
And that national security and economic and technological competitiveness are the metric we should be using. 2, I think that we have long held and allowed the judiciary to make decisions about intellectual property cases, oftentimes by the time they go to the Supreme Court, they're corner cases, that have been informing our innovation policy. That is not the appropriate place for innovation policy to happen. I think Congress should take a very proactive approach in deciding how we want to use our innovation ecosystem to our economic advantage. That would be the second thing. And the third thing would be to look at all of our choices, PTAB, the USPTO, other things, and say, are we holistically achieving what we're trying to do? We have 200 plus years of an intellectual property system that we have been making incremental changes to over time, and no one has looked at the entire system and says, does it meet our needs? Why don't we take a new look and actually come up with some comprehensive viewpoints about what is required for this new metric?
Okay, anyone else want to add something to that? Mr. Cohen?
Thank you, Senator. It's an excellent question and obviously one that's hotly debated. Just a few observations. One is that I think when it comes to issues involving state actors, particularly from China, PTAB proceedings, I think it's very difficult for ALJs to balance those foreign policy interests, to recognize what is the significance of a state-owned enterprise, to recognize whether a particular industry in the United States might be targeted. I think those kinds of issues might be more appropriately decided by a Article III judge, just due to the complexity and the fact that it extends beyond the narrow confines of a patent. I would also note that with regard to these concerns about the real party of interest or standing issues in PTAB proceedings, that there is a phenomenon in China in IP, and frequently Chinese phenomena appear in the US, where sometimes there's artificial litigation or straw man litigation in administrative proceedings. Artificial litigation is a case where the parties are not really adverse. They want the court to make a decision that would benefit one of them, perhaps a plaintiff or perhaps a defendant. I sometimes wonder whether the Huawei versus ZTE case in the EU involving standards essential patents may have been an artificial case in order to obtain a certain decision from the European Union that would benefit China, in Europe, the United States, and other markets.
Okay, in that regard, let me ask you this. Last year, the WHO gave a TRIPS waiver when it came to manufacturing COVID vaccines. What kind of, or do you see it as a wet blanket, or do you see that as unfriendly to fostering innovation? If somebody producing a vaccine without the rights holder being able to take that and move forward.
Yeah, I think earlier in this panel, we were tallied for who supported that. I think no one raised their hands, both with the respect to the TRIPS waiver and the proposed extension to diagnostics and therapeutics. Obviously unfriendly to IP rights, and also a door opener to a range of other concerns, whether it's green technology, non-COVID vaccines, or certain forms of technology that may have other applications other than in dealing with a pandemic. Addressing the pandemic itself, obviously an international public health concern, and the remedies for that are not limited to and not necessarily dependent upon violating our IP rights.
Right. Thank you all. Thank you, Mr. Chairman.
Thank you very much, Senator. I understand there may be one other senator seeking to join us, but the ranking member said if there wasn't by the time I finished my last question, I was welcome to simply gavel us to a close. Let me ask just a few closing questions, if I could, of the panel about ways in which I believe that our IP system's been strengthened, has been weakened, and proposals that might strengthen it. I'd just be interested in hearing, if I could, Ms. Harrison, about what role you think an intellectual property enforcement coordinator could play, the urgency of filling that position, whether it'd be important to have a coordinator across the administration. You talked about identifying the central role of the PTO, In my view, this currently unfilled position is an important one, but I wondered if you had any views on that.
Thank you, Chairman. I think that it's an important role to fill because it is the closest role to the White House that deals with intellectual property. It has not historically had a unified view with the USPTO or with other USTR and other organizations about how to handle IP in the economy.
Right.
And so I think that, what we're hearing today is IP is becoming more important to what's happening to our nation. And so it needs to be at a higher level position and discussion within the administration. So I think filling that is our only hope at this moment. But I do think that having more coordination between the USPTO and that position would be helpful.
Based on your previous testimony, I assumed you would say that having USTR, PTO, Commerce broadly, and the IPEC have a common view about the value of strengthening U.S. IP is as important, if not more important, than actually filling the position.
Correct.
Mr. Cohen, if I might, Professor Cohen, what's been the impact of the eBay decision which made it difficult to get injunctive relief in terms of strengthening the fundamental rights of patent holders?
Thank you very much. It's a critical question. And again, my area of expertise is comparative. And I can tell you that in China, injunctions are automatic. Injunction rates are 95% or higher. And the only reason they're not 100% is sometimes the patents are no longer in effect by the time the court decision comes down. So basically, it's the rare instance where an injunction is not granted for any kind of IP infringement. This is a comparative disadvantage for the U.S. because it's not a certainty that an injunction will be awarded. Our damages are high, but litigation takes time in the U.S. and it's quite expensive. In China, you're 6 months first instance, 3 months appeal. So 9 months and your case is done. In most cases in the U.S., they haven't initiated discovery at that point. So you have an injunction. And if you have a global litigation scenario, that injunction, if the goods are manufactured or sold in China, can be extremely valuable, not only in compelling a resolution in China, but a global resolution. And this has happened many times.
And would having a restored right to injunction or an assumption of injunctive relief in the United States help balance that out?
Well, I think it would certainly, it wouldn't necessarily collapse the amount of time till a final adjudication, but the availability of a preliminary injunction could certainly help in that regard.
There's also been reference here and in the previous hearings that I've held with then Chairman Tillis about the impact of a lack of clarity about patent eligibility. To be generous, the Supreme Court's jurisprudence has wandered a bit in terms of clarity. What are the consequences of having a yawning lack of clarity about patent eligibility?
Well, lack of clarity decreases the attractiveness of patents as a basis for investment and capital formation, manufacturing, and everything else attendant to that. I view lack of clarity as at least as big a problem as the substantive eligibility issues. Again, to make the comparison, China generally grandfathers prior decisions that are more respective of property rights. So they will rarely run into this problem where their court has made a decision that is uncertain and narrows rights because you'll generally be grandfathered, at least with respect to the rights you have. But if you have instability, it not only affects you prospectively, but for previously granted rights, they could be invalidated.
Thank you, Professor Cohen. I'm about to close the hearing. Any other concluding comments? Mr. Kilbride.
Thank you. Because I think your last question was so important. I want to say how important I think it is to afford our intellectual property the characteristics of a private property right, with all the all of the benefits that accrue to that. And if you want to think about why that's so important, we need only ask ourselves, how much would any of us pay for a car if we had to leave it on the curb with the keys in it every night? Probably just enough to use it for a few hours. And that's exactly how much American entrepreneurs and creators will invest in their innovation and creativity if we allow our intellectual property rights to continue to be eroded.
That is a good and frankly, in some ways, painful metaphor in which to close, Mr. Kilbride. I view it as a constitutionally created and worthy of protection property right. Thank you to all four of you. I appreciate your time and your diligence, your patience with our delayed start because of votes. I'm also grateful to the members and their staff who attended, to my own staff who helped prepare me for this, and to Ranking Member Tillis for being a great partner in choosing such capable and talented witnesses and holding this hearing today. I think it's important for us to understand that although nation states use both legal and illegal means to threaten our IP, they are seeking to unseat us as the world's innovation and technological leader, and in some cases they are succeeding. And so you've offered us some pointed answers about how we should respond to that. You've reinforced there's much more we can do to maintain our competitive edge, to strengthen our own IP rights, and to get our own house in order. I am in wrap-up, Mr. Senator Tillis, my ranking member. If you have any closing comments, you're welcome to make them as well. I look forward, I was just saying, to working with my colleague, Ranking Member Tillis, on solutions that will allow us to both think critically about the important role IP plays in our national security and our economy, and to address some of the critical ways in which our own IP system has been weakened in recent years. Members can submit questions for the record for the witnesses due at 5 p.m. 1 week from today on April 25th. I know the ranking member has a number he intends to submit. Any other closing comment? Senator Tillis.
Yeah, and actually we may be able to make that easier rather than having you all respond to the written questions. We can just get on a conference call. Maybe we'll do that and submit some other ones where you don't have an immediate response. But I really do, but I had to step out briefly for an interview, and surprisingly it was about China. It was about TikTok, actually, and the exploitation of the Chinese Communist Party of about 120 million, potential exploitation of 120 million U.S. citizens who are users of TikTok, a third of our country. And I really believe that idea of the whole of government, when it comes to enforcement, when it comes to commerce, that we need to sit down and stop playing checkers and start playing Go. The Chinese Communist Party is extraordinarily sophisticated, and we are playing an old game and old rules. And we have to think creatively about how we can, in an area like this, where we have bipartisan consensus, as we often do in the IP subcommittee, we need the best minds and perspectives on what actions we need to take. And we look forward to your continued engagement. Thank you all for being here.
I agree. I look forward to working with you. Senator Tillis, I agree we need to change the narrative about American intellectual property, but we also need to change the trajectory, coordination, enforcement, and taking the initiative. I look forward to our next hearing, and with that, this hearing is adjourned.